SJC-11531, Patrice Gianareles v. Patricia Zegarowski, et al.
Thank you.
All set? You may proceed.
Good afternoon. I'm Glenna Goldis for Patrice Gianareles. After adoption of Megan, guardianship of a minor is the one remaining context where the courts remove children from their families without appointing counsel to the parents. And guardianship is an especially dangerous type of proceeding. In this case, the petitioner had a 4-page court activity record, and 2 witnesses told the court they had seen marijuana in her home. She admitted that she'd lied under oath to win a restraining order against her husband. And she had a lawyer. The teenage mother did not have a lawyer. She was crying during her presentation. There was never any inquiry into the petitioner's history with DCF, and the mother never participated in a trial or evidentiary hearing. Instead, the mother just stopped fighting. She signed a consent that gave up everything there was to lose at trial, plus the right to be notified of hearings. It gave her no right to see her son and no say in how child support would be determined. Her reason for signing away her rights eludes the record, but we do know that she signed another agreement stating her parental rights would not be terminated, even though those weren't at stake. And she filed a petition to remove the guardian just 5 months later. It appears that the court provided very little process to the mother, and that it entered a decree based on a consent that she did not make knowingly. This is bound to happen sometimes when parties are unrepresented. But because this decree deprives the mother of her fundamental right to a relationship with her child, it's unconstitutional.
So why is the appropriate remedy not to make a due process appeal of the denial of the Rule 60 motion to the appeals court as opposed to coming here under Chapter 211, Section 3?
Well, a review of the denial of the 60B motion would only review what happened after the decree and the judge's discretion there, and not the proceedings leading up to the decree, which is what we want to litigate.
But isn't the ground under Rule 60 a denial of due process for the underlying judgment?
There's law specifically on point saying that the court is not to review the proceedings leading up to the judgment itself, only whether the judge properly exercised discretion.
Well, but if you've got a constitutional issue, that's going to sort of change the discretion. I mean,
well-
couldn't you raise in an appeal from the Rule 60B motion the precise constitutional argument that you're making here?
Another reason to come to the SJC for this case is, there are several reasons. This court has held in the past that child custody matters deserve to be heard as quickly as possible, and therefore in front of the SJC. Brantley also lays out considerations for this court to use, and this case falls squarely under it. It's a matter of constitutional rights that have been violated by a court in a systemic matter, and judicial economy favors resolving it under this. The main thing that separates guardianship from termination of parental rights is the parent's ability to file a petition to remove that guardian. But removing a guardian is difficult and takes a long time. In Hillary, this court noted that removing a child for even 6 months is a substantial deprivation of the parent's liberty interest. In this case, the mother filed her petition to remove 8 months ago and still has not received a trial date. The lack of rights in guardianship undermines the rights granted in termination by Megan. It undermines Megan because the standard at termination is parental unfitness. This takes into account the parent's bond with the child. If the parent has not seen the child in years because of a guardianship decree, then she will be in a weak position, regardless of whether she has a lawyer. The lack of rights in guardianship undermines the statutory scheme governing state intervention. Those statutes and regulations protect family integrity in a number of ways, including by providing reunification services and appointing counsel to indigent parents. The Guardian statute provides none of this. A Children's Law Center study found that DCF workers advise their clients' relatives off the record to file for guardianship. That way, DCF can close the file without providing services to the parents. And the parents fight for their fundamental rights pro se. One might argue that guardianship is different because DCF is not a formal party. But in Hillary, this court granted parents the right to appointed counsel in Shin's cases at the dispositional phase, noting that DCF was a party to them, quote, as a practical matter. One reason was that the hearings could result in DCF having custody. Guardianships are similar. Probate court judges are authorized by statute to order children into DCF custody. It's especially likely to happen during a guardianship hearing because the types of allegations being made are the same allegations that triggered the sua sponte orders into DCF custody. In addition to protecting fundamental rights and children's safety, appointing counsel to parents would promote judicial economy. When parents don't have counsel, guardianship proceedings are inefficient. Parents may sign agreements they don't understand and then return to court to try to undo them. Parents might not know when to stop fighting. Parents might not know what to focus on in their presentations or how to expose bad faith petitions. So the case keeps coming back to court over and over again.
Well, so what is the role of a probate court judge in a guardianship proceeding with an unrepresented mother, for example?
So the judge's role in that proceeding would be to hear what the petitioner has to say and make a ruling on that. She also, of course, has the duty to provide process to the parties as is appropriate depending on the type of case. So she would also be the one to appoint counsel.
Okay. So you're suggesting the judge's role in all of this is not adequate to protect the rights of unrepresented litigants?
As that role has been practiced in this case, no, it was not adequate.
Are there pending proceedings?
There is a collateral proceeding. The mother has filed a petition to remove the guardian. That proceeding, of course, is not addressing her fundamental rights, which were at stake in this original decree. It's something following up on that.
Counsel has been appointed?
Well, actually, she has counsel in that proceeding because she found counsel after the decree through legal services.
And counsel for the child?
The child has also been appointed counsel in that proceeding.
And where is that? And that's the goal is to remove the guardian in that proceeding?
Yes, that is the goal, and return custody to the mother.
Mm-hmm.
So fundamental rights should not be defended by amateurs. The law already provides counsel when the state seeks to remove children temporarily and when private parties seek to remove the children permanently. We're asking this court to just complete that scheme and find that indigent parents being sued for guardianship must be appointed counsel. And going back, the guardianship proceedings we're talking about are actually really complicated, and because of that, they're prone to error. There are a lot of issues at stake. It's not just the fitness of the parent, it's also the suitability of the guardian. It's legal custody and access to records. It's whether the child will end up in foster care. It's child support. There are issues of parental alienation. There are often drug testing and reunification services issues. There are social workers, there are expert witnesses. There's visitation issues, not just whether there is visitation, but where it will be, and whether, especially in suburban areas, whether the parties have transportation to effectuate that. And as usual, there's issues of credibility and hearsay. There's a lot of speculation that's raised. All of these things require the party to have counsel in order to defend her fundamental rights. And if there's not counsel, then there's going to be a high chance of error, a high chance of erroneously depriving a parent of her fundamental rights. It's also important to note that finding this right would not affect all guardianship petitions. According to the study that I mentioned earlier, 94% of these petitions are uncontested, and some of the remaining cases don't involve indigent parents. So it could actually be a narrow type of...
Let me just ask a clarification. You mentioned the study earlier that DCF, now formerly DSS, is actually the silent moving party behind individuals proceeding to the probate and family court from the juvenile court to seek guardianships. Are you proposing, nonetheless, that even where that is not the case, because generally, if you're in the probate court, you know that. Party will say, I'm here because the social worker sent me here. Are you saying that even between two private individuals, where it's contested, there should be appointment of counsel for the parent and the child?
Yes, for several reasons. First, because of comparing to the termination of parental rights issue, and second, because DCF, even when they haven't told somebody to go to court, DCF and foster care are always on everybody's minds, and so DCF is very much a presence in all these cases. Like maybe DCF hasn't been involved yet, but the guardian's saying, if you don't give up custody, your kids are going to end up in foster care. So there's that connection, and it's also, and sometimes, DCF, they could potentially be involved. And as I said, this is only one part of the argument. Also, this is very similar to termination of parental rights, and it's a substantial right that parents are being deprived of when they need a counsel to defend it.
So you say it's similar, but what's the standard for undoing a guardianship as compared to termination? Termination's final, right?
Yes, so there's the issue of what the standard is and how long it takes. So the standard is fitness of the parent, and as I said, this is hard to show after there's already been a guardianship decree depriving visits for a long time. But in addition to that, this court has noted in Hillary that depriving a parent of this right for just 6 months is substantial. That's a substantial deprivation. It takes longer than that in practice to effectuate a removal petition in the probate and family courts. As I said, in this case, it's been 8 months so far, and there's no trial date scheduled.
Thank you, counsel.
Thank you.
Good morning, Your Honors. My name's Karen Galat, and I'm here this morning on behalf of the guardian, Patricia Zegarowski. I have been working on this case since the very beginning. I was working for the Lawyer of the Day program on the morning of July 17th of 2012 when Ms. Zegarowski approached me along with the biological mother's parents and indicated that they needed a petition for emergency guardianship. There's a lot of paperwork involved. I worked with them until the Lawyer for the Day program closed that day and then received permission from Pamela Casey O'Brien, the Register, to file a pro bono appearance on Ms. Zegarowski's behalf. And I've been involved with the case ever since. There are a couple of things that happened that my sister referenced prior to her involvement last May that I would like to clarify. First of all, the child was never removed from the mother in this case. The child and the mother were living with my client from the time the child was 6 months old. And at some point in the spring of 2012, the exact date I think is in dispute, but at some point that spring, the mother left and the child remained in the care of my client. And she actually came to court with the mother's parents in July because the police department had suggested that she do that after a dispute had occurred at her home. And her petition was supported by the mother's parents, particularly her father, because at that time the mother was a minor. So I think that that's an important distinction here. Also, the mother never filed she never signed any kind of an agreement that referenced her parental rights. In fact, at one point, and again, this was prior to my sister's involvement, this case was heard down in Family Services at Essex Probate and Family Court, and the family service officer appointed to the case, the child's father at that particular point in time was not incarcerated. He has been for most of the child's life, but he was present that day too, along with the mother. And the family service officer explained to both of them, this is not a termination of parental rights. And if you find after a period of time that you are capable of taking care of this child, you can come back to this court to do that. So I think that that's another important distinction. The case continued. The emergency guardianship was awarded in July, and it was reheard again. This case was in front of Judge Rickey when she was still in Essex County. It came back to the court on August 1 at Judge Rickey's request, and on that day, and I think that my sister has had a little bit of a disadvantage here in that the recording of that hearing is not particularly clear. I have the advantage of having been there. The mother stated to Judge Rickey that she had a lawyer and asked for a continuance so that she could come back in on a time that her lawyer could be present. And in fact, that individual was identified during that hearing, and I don't recall who it was. And the father also subsequently said, I want to have a lawyer. But neither of them ever came back. The mother never came back to the court after that. The father did come at the pretrial, but not subsequent. The mother didn't even, she was in the building the day of the pretrial conference, but she never came into the courtroom, and neither of them attended the trial that was held in front of Judge Rickey on December 27th of 2012, when she determined that the parents at that particular time weren't capable of taking care of the client. Now, since my sister's been involved, she is the lawyer for the mother in the 190B petition to remove, and she is the lawyer for the mother in the 60B case. So since she's come on board, she has, as she should, thrown everything at me she possibly could think of, and the 60B motion was one. And when Judge Rickey denied the motion, she brought it up on appeal, and had she left it at the appeals court at that time, I think that the issues that are concerning her and that are now being raised by her client would have been adequately addressed by the appeals court. So I took issue when she brought it up to this court under 211 Section 3 because, as is noted in the statute, there's an adequate remedy. There is another adequate remedy in that she could have just left it in the appeals court to be heard. Further, the removal case to which both my sister and I have referenced under 190B is set for a pretrial conference on February 7th. In that case, in addition to myself and my sister, there is an attorney for the child, and there is also a guardian ad litem. And so Judge Kaplan, who has now taken over for Judge Rickey, since Judge Rickey's gone back to Worcester, is going to be in the unique position of having a lot more information available to her. My guess, I could be wrong, is that that case is actually going to be tried sometime in the early spring, and depending on how things work out, the result of that case could come down before we receive Your Honor's opinion. So under the other part of the 211 Section 3 case regarding the furtherance of justice and so on, and whether a constitutional argument might be appropriately brought before this court under 211 Section 3, I want to raise the case of Brown-Madison that Your Honors decided on December 11th. That, of course, was decided by Your Honors after our briefs were filed, and the underlying fact pattern is very different. But it seems to me, from the information I was able to glean from that case, and that was SJC-11531, decided on December 11th, that it is an identical issue in that Your Honors determined, had the case been left in the appeals court, the underlying substantive issues would have been addressed there, and further, that that was the appropriate case for the constitutional or statutory arguments, whether or not they were matters of first impression. That leaves me, therefore, raising, again, the question of Mass General Laws 231-6F. As I noted, I am pro bono. I am not seeking attorney's fees here for myself. I do feel, however, that the mother and her counsel have been overreaching a bit. We have a remedy available to us. I think that for both of us to have been down here today, giving up the time that we would have been able to work on other cases, I know I'm out of pocket on my costs in excess of $100. I can bill my client for them, but I don't think she can pay the bill. If I were charging her, my fees would be up around $4,000 for the 2 briefs that I filed and my appearance today. I am asking that the mother be sanctioned and that any amount that Your Honors feel is appropriate under 231-6F and under the case of Lewis versus Emerson that deals with frivolous appeals be awarded to perhaps the Essex County Lawyer for the Day program or to any program the Mass IOLTA Committee might think is appropriate, just so that we can keep things under control.
Thank you very much, counsel.
Questions? Nothing? Okay, thank you.
All right. Hear ye, hear ye, hear ye.